organized within the framework of the third conference of the Escazú Agreement on behalf of the High Commissioner of the United Nations for Human Rights and on behalf of the Program of the United Nations for the Environment. We would like to welcome everyone. This side event is called Criminal Environmental Right, Avoiding Criminalization of Advocates for Human Rights and the Environment. And to start, I would like to give you the agenda of the day. First, I would like to remind everyone that we have simultaneous interpretation. It is available for everyone participating. And first, we would like to welcome the representatives of the organizers and then appreciate the company of the important panelists joining us today. To start, I would like to provide some context. And to introduce the event, I would like to give the floor to Javier Mena, Regional Representative of the Regional Office for South America of the High Commissioner of the United Nations for Human Rights. Thank you, Javier. Thank you, Maria Alejandra. My name is Javier Mena. As she says, I'm the joint representative of the Office of the High Commissioner for Human Rights of South America. I would like to apologize because I'm very sick and I coughing. So hopefully this won't interrupt the presentation so much because there's a virus going around in our office and I do apologize in advance and I appreciate your understanding. Okay, so I want to know if everyone can see me. Okay, thank you. We can hear you and we can see you. 1 second here. Just 1 second. I do apologize for this inconvenience. First of all, I would like to say hello to everyone. I want to extend a very warm greeting from the High Commissioner's office. For me, it's a huge honor to introduce this official parallel event within the framework of the COP3 of the Escazú Agreement, which one of its focus is protecting advocates for the environment. I'm a lawyer, and this is an issue that I'm very interested in. What we're going to read and what we're going to discuss in this side event. And this is why we believe that it's very appropriate to have the conversation about criminal right and how it has played an important role in the prosecution of advocates and defenders of the environmental rights. But on the other hand, it's important to highlight how criminal laws have a crucial role in protecting the environment and fighting climate crisis. And it's interesting, this duality of persecuting and protecting. And this is what we're going to talk about in this space. And as a positive aspect, we have to say that criminal environmental law has a crucial role in protecting our planet and its assets in the fight of the tribal crisis, setting regulations, setting sanctions to protect and prevent all crimes against ecosystems and biodiversity. And these laws have a wide range of activities from industrial contamination, illegal forest lumbering, protecting animals, water rights, and those who commit against these kinds of actions and protecting these collective assets. We believe that strengthening these kinds of regulations is essential when answering to the tribal crisis of the planet. contamination, pollution, the loss of biodiversity that we are facing on a global level. And we find ourselves on a very critical level. And this is how the General Secretary mentioned, Mr. Gutierrez said that as a humankind, we are on the edge of the abyss because of all human activities of an unsustainable development model. These activities have exaggerated this crisis, making ecosystems unstable and have risked many species. Having these criminal laws can and has to contribute to address this crisis, discouraging noxious behaviors and promoting sustainable practices. Now, on the other hand, we need to recognize that criminal right has been inappropriately used when restricting personal rights of those who defend the environment, advocates and defenders of the environment, including indigenous communities, Afro-descendant populations, activists, often face legal retaliation because they oppose development projects or because they denounce its execution. And it's crucial for us to strengthen the legal protections and so that we can promote safe environmental a safe environment for them. Human rights advocates face a series of threats in criminal laws, especially when they are involved in the environment. And I want to mention some of the threats that we've identified. First of all, criminalization. They are criminalized and they're prosecuted after arbitrary application of the law. For example, they are accused of sabotage, incitation to violence, or alteration of public order, trespassing, among many others, without any solid grounds, as a tactic to silence, affecting not just their own private freedoms, but their psychological integrity, their families, and their organizations. The second thing is harassment and violence. Advocates and defenders of the environment are object of harassment, physical violence, even attempts against their own lives by state organizations or non-state organizations. And this might include arbitrary intimidation, I'm sorry, harassment, vigilance, among many other things. And they use the legal system and they use administrative processes or civil lawsuits, and they are used to start legal process without solid grounds, which stop legal processes. And it means spending resources and risking their jobs. And sometimes it's hundreds of procedures. And this phenomena was called legal harassment. At what point stigmatization and defamation is in slandering? Because it's very common to hear that these advocates are stigmatized and they are slandered as anti-development agents. They are called terrorists, as foreign agents, and a series of names that come with the objective of undermining their public support. Now, the fifth is the selective legal objectives. Are some of them face legal procedures that are disproportionate, that do not apply to the same situation. Just to sum up, environmental advocates face legal and criminal harassment and violence. And this tries to impede their work. And this has to do with human rights. This is why it's crucial to guarantee their protection and the safety of those who defend nature in order to promote a sustainable development and a just development. And now to wrap up and as a conclusion, strengthening environmental criminal law is urgent in these crisis times. Only by applying laws in a fair way, we will be able to face the triple crisis of contamination and loss of biodiversity, among many others, to make a more sustainable future for everyone. those are my opening remarks, and I greatly appreciate the invitation to participate in this event. I've been participating in other activities of the COP, and I think it's been a very rich space to understand, to know different opinions, to listen to different debates. And I think these are elements and these kinds of activities encourage, create discussion, and they create debates. And that is the most important characteristic of the Escazú Agreement, that encourages and promotes the debate. Thank you so much and good luck. Thank you, Javier, for those opening remarks and for that introduction that gr- greatly outlined the improper use of criminal law in our region. Now, Andrea Brusco will mention a few words, joint director of the Office of the High Commissioner for Human Rights of the Environment. She will not be able to join us today, but she has sent us a short message through a video that we're going to show now. Thank you. Good morning. I would like to say hello to everyone. I'm Andrea Busco of the Program of the United Nations for the Environment. I'm very happy to join you in this event on the framework of the COP3 of the Escazú Agreement. This left great results with the adoption of a decision that adopts the plan for advocates of the human rights. This is a great news for everyone, particularly for those who are on the ground defending the environment in Latin America and the Caribbean, defending our rights to a healthy environment. The three crises of loss of biodiversity, pollution, and climate change are connected on a great measure with the exercise of illegal activities that do not respect the boundaries of nature and do not respect the limits of the law. We've seen in the past few years that criminal law is being used exponentially to prevent and also to repress illegal activities linked to the environment. Environmental crimes, environmental flaws have increased the complexity of these misdemeanors and with more complicated and complex crimes. And the legal community is being mobilized with more solid laws, with more solid grounds in order to avoid and repress environmental crimes. And we've also seen that in some cases, criminal tools and legal tools have been used to repress those who defend Mother Earth and nature rights as our own right to our healthy environment. So it's very important to pay attention to these issues and to be able to identify in which cases these tools of criminal law are being used improperly. Of course, in order to address and facilitate advocates and environmental defenders so that they can do their activities freely without threats or restrictions. These situations that we have seen in the COP3 affect very directly, especially women, young people, rural women, indigenous people, those who are on the front lines when defending the environment of Latin America and the Caribbean. This is why we are very thankful to participate in this activity in which we're going to work on these issues. We want to thank especially our colleagues from the High Commissioner of the United Nations for Human Rights, with whom we've been working in these issues. And also we would like to thank those who are kindly offering their time and are available in order to collaborate with us as speakers and panelists. Thank you so much, and we hope to keep working with everyone in these issues in order to strengthen the right human rights for Latin America and the Caribbean.
Well, now thank you, Andrea Brusco, for that message. Next, we are going to start our panel that is here today with us. We have the presence of 5 panel members that are going to help us with their comments about this topic. Each one of them has 7 minutes for interventions. And after each intervention, no, after all of the interventions, we are going to have a Q&A session where we are going to receive questions in our YouTube channel. Well, we are going to begin with the first intervention from Gregorio Mesa Cuadros. He's a professor in the Faculty of Law, Political Sciences and Science of Colombia. Thank you so much for your presence here. The floor is yours. Thank you. Good morning, everyone. It is an honor being here with you today in this panel as a parallel event for environmental protection. The intervention that I have denominated human rights and environmental rights after the political context. And we're going to talk about the environmental context and also some elements of response to the current threats that goes beyond the law. So first of all, when we have different sectors that are segmented in daily lives that have more than 5 cycles of evidence here in the world, it is necessary to transform that reductionist vision and to understand as environment the cultural and ecosystemic context, because the Latin American context is a very diverse in nature and different species of the biodiversity, but also in culture, with almost 1,000 cultures for everything that we have here, and also with thousands of farmer cultures with different cultures and practices outside of the ones that are imposed by society. So this leads you to say that the Caribbean and Latin American context is a promoter of biodiversity and different cultures, thinking on the legal state matters, and also the United Nations also assigning the particular right to protect this in the nature and culture. But the fact that the regulation is saying that hasn't made that the Latin American context has created that, of the constitutions, the regulations of the Latin American legal system will establish environmental protection as part of this and to respect it and comply with. So when at the end of the 90s, almost 30 years ago, the concept of a state of law for environment was implemented by an environmental justice, the environmental rights that included human rights and also nature rights as a theory and a millenary practice of different cultures that made sacred nature, Pachamama and motherland, as key concepts to have a new theory of rights that could be a starting point for the defense of the rights of everyone in a 21st century that is radicalizing the current system and holistic view as well that has been known during the colonization, but that it wasn't really paid attention to. And we have moved forward a little bit, but this has been more in ideas than in material or concrete terms, because almost all states right now, companies and particular people are talking about environmental rights, but they continue defending sector and partialized views, recurring also in different aspects of the different paths. So understanding that the threats to biodiversity continue, it is necessary to overcome the rhetoric of what we are and understanding that not for that the environment and culture are protected, a concrete manner of understanding the world and life, where we have a hemology that is a part of that biodiversity, trying to use cultures and biodiversity around consumption and extractivism, for which the colonizing programs are part of. Also, the idea of ecosystem cannot be touched by humans is something that we keep believing, and that in the majority are related to what the international law says, that these are collective subjects for constitutional protection, such as people and different native communities that some authors still believe as reduced individuals, but in Colombia, in the last constitutional reform, they became being especially protected individuals, and they contribute significantly to the construction of a nation and culture protecting the ecosystems. But in turn, they are accused of being illegal and opposing to development. So private companies and public as one, national and international ones, accuse their leaderships and organizations and communities. They are persecuted, they are victimized, and also to promote concrete practices of forced displacement to continue having the destruction of environment, cultures, regional and international, for corporations, groups of interest, and states. Secondly, the second part of my talk, and paying attention that as environmentalists, we are working on the principle of prevention to environmental destruction. We need to improve the conditions, and we believe that we need to go after or beyond the criminal law against those that could be wrongly using the natural heritage. Our experience of more than 30 years in environmental law has shown the little effective that establishing as a crime any conduct of this matter, forgetting that historically all these relations are persecuting the poorer but not big companies that have been determined as the green ties because they are trying to just skipping what other people are trying to defend, and also in the different farmers communities, as we have seen in Colombia in the case of Amazon, that are part of the nationally recognized people, but this will contribute to resolve the environmental conflicts in specific territories of tropical Amazon and other areas as well. Therefore, what we're doing needs to be or translated as a new world vision and life that will recognize different scales, multi-space in an environmental issue in some sense, where we cannot be over nature or under it, because we depend on nature, and also we have the obligation to be responsible. We cannot forget about this responsibility that is shared. Second, according to our human conducts, corporate or public behaviors, in order to avoid using in a bad way the idea of living in this world. We completely oppose to that concept because we consider that we are not in that age, but we are in an age of androcentric or capitalocentric, as whatever you want to say, for three main reasons. The first one, the right to use nature has been said over and over again. That is why this is androgenic. Second, not all human rights contaminate the systems or cultures in the same manner. Third, capitalism at the end of the 20th century and the beginning of the 21st century has acquired new ways of damaging the deterioration. And also, it is important to recognize that we are a very diverse continent, but it is not enough for this. We require to have carers in ecosystems from practices that are responsible with the natural dynamics that also could help us to prevent environmental damage and to not increase the climate crisis and migration crisis as well that is happening now in the world. Understanding that means that we need to start with understanding less repression, and also to establish the limits, specifically when we're using ecosystem to sustain the basic needs. Third, to overcome sectoral visions for others that are integral. And fourth, to overcome different conservationist views versus when these ecosystems are only at the service of the capital. To finish, the academic and entrepreneurial aspects need to understand that these military forces and also state forces that will favor the deterioration of the environment. Criminals need to be stopped in their behaviors, but also they need to contribute to the micro powers of the communities and their leaderships that are raising against the micro powers of corporations, and the state nations also granting authorizations, not persecuting them, and evaluation of the product of the projects, and to continue persecuting the poorer in order to have that as a weakest link. This behavior that connects with the deterioration of the environmental impact needs to be denounced, recognized, and overcome. Also, we need to consider what has been wrongly obtained by criminal environmental matters, and also to consider other species as well, some attitudes of the environment. So thinking about the human side of things and ecosystems as well. Thank you. Thank you, Gregorio Mesa, for that, those contributions to this discussion. Of course, we need to consider the definition that you have given us about the environmental context, considering the ecosystem regulation and the cultural aspects as well is of great interest. And also, thank you so much for mentioning the difficulties that are structural when we are applying the regulations of the criminal law in these matters. Next, we have the intervention of Carmela Curup Cajon. He is a director of the Buffet for Indigenous People in Guatemala. Thank you, Mrs. Kurup, for joining us and participating in this event. The floor is yours. Thank you. Thank you to the High Commissioner of the United Nations for Human Rights. It is very important. I wanted to establish the challenges that Indigenous people are facing in front of the criminal laws in the region, and also the criminalization of Indigenous people. First of all, I would like to consider what the previous panel member said. Diversity of the world is limitless. There are several ways of thinking, of feeling, to understanding life, to conceive time, those relationships of human rights of human beings as well. And the most important thing is understanding the world from Indigenous people. Where it has been said, this is recognized as well, that way, and that division between the cosmos related to ecosystems, water, and nature, and that holy character that establishes a new vision. And starting from that point of in that vision, we understand a very strong contradiction facing other regions that are trying to implement a model where the human beings are destroyed and nature, everything that we talk about exploiting resources, when we talk about seeing resources as a merchandising, and to promote every type of any type of destruction. So we're having a globalized market vision that is carried out by international companies, economic interest, with the purpose of mining exploitation, oil, electric. But we see all of this correlation of forces that are totally unfavorable to that world view that is said or is proposed by the indigenous people. And that is how we can see that these economic forces of a transnational character is going over and are imposed on national governments such as ours, as a debilitated government with a very regulations in terms of political aspects that are trying to take away the rights of indigenous people. Remember all of the imposing that happened during the colonization in all of the Latin American countries, with that view that took away from the invasion to today. It has been cycles and cycles of resistance of indigenous people that do not want to suffer all of that imposition of colonization. And as part of those frameworks, we have faced a series or a number of genocides trying to survive and impose to this phenomena. So I would like to say that indigenous people have some mechanisms that are based on international standards that in some way protect their structure of communities, the way of relating and government with nature resources. We can see the free consultation of people, and governance of the territories, and that makes that from that framework they can create aspects related to the taking care of animals, life, trees, forests, to establish different mechanisms of supervising and to control and monitoring systems. But you know that since our states are a state where is favor just a sector of the population, and we have said that in the sectors where all the wealth is concentrated in Guatemala, this is where they have the economic, social, and political control of all natural resources. So this scenario that I'm establishing here implies all of these big challenges for the well-being of people. And I have said that the standards and the international mechanisms, we as demanding people, is a foundation that we use in order to sustain our claims, with the purpose of accomplishing that in some way we can move forward and to respect the previous consultation and what is free determination of people. But it is important to mention as well that there is a politic of appropriating indigenous territories, such as the declaration of protected areas in consultation. There are many times during the indigenous people's lives when in a given moment they see that there was approved an area for reserves without the consultation to indigenous people, and the next day indigenous people feel that their natural resources and lands are taken away, and they face the usurpation crimes in protected areas, and also to say that in different demands that have been promoted by indigenous people in international standards, in some moments we have been able to generate some precedent when it comes to consultation. This has been regulated, or we have made different claims over these 5 years for exploitation of mining industry, and also for gold and silver, where we have said to the Court of Constitution that by not consulting, then this should be suspended. That is how some standards were created or generated, and it was forced the paralyzation of at least 5 licenses. But if we work on recounted the licenses that are imposed right now in the country, with no type of consultation, considering the environmental and how we can see different aspects of these elements. And the big challenge is what the government can do in order to have a review. And in some way, we have some completely complex scenarios. And on the other side, the pressure of these companies and monocultures that are over the indigenous people's land, and this has provoked some forced displacements. And we have an institution that is created for the criteria of identifying indigenous population, and we have 2,500 conflicts related to the indigenous lands, property, and territories, and we don't have a legislation that is specific on this, so we don't have any certainty on the land, and even less on the resources and natural resources as well. So all of those threats make indigenous people, in attention to their manifestation right and Pacific Union, is why we have demonstration, we have different vigils as well, so they can raise their voice, so we can respect their territorial rights. But in this framework where we have the intervention of the repression, as it is the security or safety forces, in order to suspend some exception states, that immobilizes the organization for communities that is impacting severely the collective rights, such as the territorial governance and self-government. And when we talk about criminalization, that in the case of Guatemala has been the only mechanism that is being used in order to take care of those social and structural matters. We have said that a judge does not have the tools and the mechanisms in order to find a solution to this type of situations. And we have found that in the case of the public ministry from 2005 to 2016, 40 46,000 claims have been made for usurpation crimes, and this is against territories, against communities from the indigenous people. And up to this date, we have 25 indigenous communities that are completely, we're talking about parents and children that are being affected. 300 women, indigenous women, that they have been escaping a capture order because they have been prevented from having public services. Children do not have access to education because when the state knows that this indigenous population is talking about education rights and public services as well, the well-being of children is on the line, and there hasn't been any policy that is trying to decriminalize or to understand the social concepts and conflicts. So finally, we have a reform for the Inter-American Court in 2016. In 2017, has published that says that 125 of orders of a living land for indigenous people. We can talk about 10 communities that have disappeared due to forced displacement, and with those 10 communities that are here, they have lost their lives, their lands, and the entire heritage, their fight. How can we repair that in the future? How we are going to be able for these communities to return and to be reunified? Because many people, many families are displaced, and that makes migration to go outside of the country. So I would like to say, finally, that right now we have 25 communities with capture orders. We've seen 15 dead when it comes to eviction. We have people that have been murdered because they're claiming their lands. There have been defendants of human rights and environmental rights that have been victims of killings for defending the forest. So there is a continuous pattern of criminalizing indigenous people because they are facing different criminal charges, and they have capture orders, but against the companies that have contaminated the waters and that they have also exploiting natural resources and consultations for 125 orders that have been illegally executed. And against them, we don't have any criminal persecution. And if we have seen some, we see a very weak Supreme Court because some judges, they don't collect the international standards in order to make a proper and appropriate interpretation for women and communities that are indigenous in order to promote and to take care of the environmental and natural resources. So I totally agree that we need to make a shift in order to change the paradigms in the criminal system, and how we can move from a state that is a positive for and to move and to be able to give this context that natural resources and these are human entities and they deserve a stronger protection. And not only because this is not only for the survival of communities, which is opposing to a civilization model that can actually save the planet facing this deep of being the praise of this, and that only sees a mother nature as just as a resource. It will be great to have this scenario. So I applaud this, and to be able to learn and to have tools in order to continue strengthening our claims and to support the fights of indigenous people. Because if we haven't been able to consolidate this model of exploitation, is because indigenous people are resisting, they are mobilizing, and they are imposing, they are against this hegemonic model that is trying to destruct nature. Thank you so much. That's everything I can say.
Thank you, Mrs. Carmela Corup. We want to thank you for providing and having taught us regarding the conflicts of the territory and social, environmental, and cultural conflicts that indigenous peoples go through and the criminalization patterns against them. Now, we're going to hear Mr. Mario Galbert, environmental advocate for Jamaica, and those who are joining us. We would like to remind you that we have simultaneous interpretation available for you so that everyone can understand what we are sharing. And also, I would like to remind you that we are receiving questions through the comments on the YouTube channel for the section of Q&A that will be done among interventions. Thank you, Mr. Garber. You have the floor.
Thank you very much. I hope you're hearing me very clearly. It's very good to speak to you all today. I'm joining you not from Jamaica where it's very warm, but from Canada where it's very, very cold. So that in itself is, a different temperature for me. I just want to say broadly to you that the conversation that we are having is very, very important for us as Caribbean, as Latin America and the Caribbean, given the fact that we are known for people from different groups, and people who are defenders of our environment, who are defenders of nature. And so it's very important that this conversation goes just beyond looking at what is it that's happening around us, but also looking directly as to see the resource or the nature that we have, or the protection of the environment that that must be done by us, and by our people. And so we look at the one thing, and I want to draw your attention to the right to a clean, healthy, and sustainable environment, that is now recognized, is widely recognized by the UN General Assembly. And that right is something that we must use everything that we have to protect and ensure that from now, every environmental regulation, be it at the national level, be it at the regional level or the international level, has this in it so that it can protect us and can protect those, future generations. I want to also look at the fact that in certain cases, at the national level, in some countries already, there is something in the constitution that look at the rights which people have, or the protection of the environment. I can speak to directly that Jamaica's constitution speaks to the healthy environment. And so that conversation is very, very important. And for us, when you look at how we defend our environment, that is something that we use every single time, or that is something that different groups use every single time when they go before the court, trying to get something overturned, whether an illegal application for mining, or an illegal application, or an application for cutting down our trees, deforestation to build houses or something of that sort. So that's a very good thing in terms of having the regulation. So a benefit of having the regulation is the fact that it will protect, or it will defend the environment. So that is one thing that we have to look at, and that is one thing that we have to say is an actual benefit. Now, a challenge is there are legal frameworks or regional frameworks that which are there, such as the ESCAZU. But the challenge is that not all countries in the region have ratified the ESCAZU. Jamaica is one of those countries, and so that is a challenge. What is in the ESCAZU and how that is important to us? That is also something that you have to look into. What does the ESCAZU does? It gives us the right to information, and if you don't have the right information, or or if countries don't give you the right information or doesn't engage with you, then that is a challenge. That is in itself is a challenge, because you are literally barred from getting the necessary information that you need in order for you to defend the environment. An environmental defender plays a crucial role, not just going into the field and protecting the nature itself, the lush or the green environment, but also to get the information so that they can stop the exploitation before it starts. And so the escazou comes in here in itself. So, for example, in Jamaica, when there are certain applications, you'll see it's gadgeted. You can't get certain, cabinet decisions. You can't get certain, application information to see who is, applying to mine this part that is already protected. And so when you don't get the right information that you need, then that is a challenge in a sense that you can't defend the environment. Another thing that we have to look into is that um, protection of different groups in the regulations. What are the groups which are protected? Are they actually protected? We may have a regulation that focuses on the protection of the different forest areas, but what about the groups which protects those informal groups or those recognized historical groups who live in these communities? Are they protected? Are they the one? They're the ones who have been protecting these environment, but are they protected? And so that is something that we have to look into, because as the first speaker been pointed out, that there are so many capitalists who are there, who are ready to go into the field. They are ready to exploit the natural resources. And so the people who live in those communities, or people who live in those sacred for me environment, the green lush forest in Jamaica, we have what we know as a blue mountain. It is a protected area, so you're not supposed to go there. But from time to time, when government changes, their policies changes and their focus changes, and so different people will try to exploit those things. And so over the 5 or 4 years, you'll see that there's a different change in policies. And so governments, when they change, you'll see that this company want to go ahead and ask for application to go mine there, and then you'll see that the law or the policy changes, and so there is a different feel that the groups are not protected, the indigenous groups are not protected. They are not criminalized for when they go against those companies who apply to mine in their environment. And so the challenge is, sometimes if it's not in the constitution, when the government changes, the policy changes, and people becomes affected. Because every 4 years when you have election, or every 5 years when you have an election, the environment, the what I would say, our governments look at the regulation change because of their the capitalist view or the conservative view, so that people try to use those as a way to get in. But when you look at the environmental regulation, we can look at another challenge with the regulation. In Jamaica, we have a very, very big challenge. We have regulation, it's called, National Environmental and Planning Agency. We have our regulatory authority, and that regulatory authority is the one that manages, the environment, the policy or the regulation. What we've noticed is that there is one part of the regulation which speaks to directly, if a country, if a company, has some sort of impact on the environment, they just give them a fine, which means that when they give them the fine, they'll come again. They'll just do it again. They'll just continue to do it. So that is a challenge. Giving them a fine is one thing, but for us, we believe that it should be criminalized, or it should be
I believe that we're having a technical problem.
me as an environmental defender goes before, if someone like me is an environmental defender, goes before the court, and or goes to this our sacred area, which is a forest, and we say um this should not be happening, or we try to ensure that we use the natural ways that we usually do to combat these things, then we will be criminalized to say we are we're in people's legal area, or we're in people's area that which they are legal, given the legal authority to mine or so. But that is not the case. It is not the case in the sense that the law may protect them, but it doesn't protect us as defenders. We're the ones who are in the field. We're the ones who are in the field. And so even now, you'll see there is a conversation about the protection of our beaches. Beaches in Jamaica is a very large, is a conversation. We know for years and years that we have the right to, to enjoy our natural resources or natural beaches. But now you have the big companies who are now coming in and they take it over. And so there are different groups who can't go trespass. And if they go there and try to open up to people, then guess what? The law will take its course and say you are trespassing in people's environment. But guess what? We have the right to it. No one should be able to to take this part of the beach because it's a private property. It's not a private property. It should be the people's beach. And so there is this conversation again about the right and the access to different natural resources for us to enjoy. So as I would have outlined, the policies change when government changes. And so and though there might be environmental regulation, the regulation may change from policy based on the government's objective, based on their view on capitalism. And so the defenders themselves have a challenge of different challenges. As I would have highlighted, the Escazú is a regional agreement, but there are different challenges with the Escazú simply because countries like Jamaica has not ratified it. So they have not ratified it, and so the applicability or the implementation at the national level, is not in place. Another issue is we need to find ways to have something like the ecocide law. I'm not sure if the audience have heard about the ecocide law. The ecocide law is a law, it's like a campaign that is being pushed now by different groups in Europe, in Latin America, in some in Latin America and Africa, whereby if a company deliberately, the head of the company deliberately goes, and apply or damage the environment, it's not the company that would, be sued or sold, but the individual who is the head of the company would actually face, the criminalization or, face the law. So that is something that a conversation that we are looking into, that should be pushed at this level, because even though it's a company, there is somebody behind the company that's actually pushing it, and so you have to start from there. I think the conversation has been rich so far. There have been different takes on we are protecting the environment and natural resources, and we are promoting the right to clean earth and sustainable environment. But there are very much challenges with regulation and gaps in those regulations that we can look to, to try to solve, or try to to ensure that they get the opportunity to defend environmental defenders, people, activists, and so on. Thank you very much.
Thank you so much, Mr. Galbert, for the review of challenges in applying these regulations in environmental law. And it's very connected to the issue that we are having today, the use of regulations, how laws are used to limit the protection of people, and also they are used to criminalize them. Now, we're going to listen to the presentation of Mrs. Ione Misai da Silva Nakamura. Hopefully, I pronounced your name well. She's a prosecutor of the Public Ministry of Parabra, Brazil. Ione is going to have a PowerPoint presentation. Yes, thank you. I want to thank you for this invitation.
importante compartilhar também recentes notícias de que os defensores dos direitos humanos em Brasil correm um grande risco e estão em ameaça, conforme um aspecto da ONU esteve acá e pôde acompanhar alguns casos. Então, trouxe uma notícia recente para que possam verificar a situação. Que foram trazidas de países africanos acá no período da colonização, e há uma fundação cultural, Palmares, em Brasil, que acompanha, que cadastra as comunidades quilombolas e certificam, e órgãos fundiários fazem a titulação das terras, porém, como se pode ver no gráfico, ainda há uma grande disparidade o número de comunidades e o número de comunidades com seus territórios titulados, devidamente titulados em Brasil. E a situação de violência, ela é muito comum em áreas rurais, principalmente porque a situação do uso da terra e da titulação da terra ainda está em disputa, ainda está em construção, não é uma situação já devidamente destinada, resolvida. E muitos defensores e defensoras de direitos humanos,
Many advocates and defenders are facing death and violence. And there are many cases of human rights violations. And you can see the figures on the screen. And there are still many conflicts in different regions. And in the Amazon region, in Brazil particularly, where there are more indigenous communities disputing these territories and are facing very violent situations. Now in the Amazon, in Brazil, in the Pará state, this has the highest numbers of violent situations accumulated in this period. They're very serious. And social categories are clearly affecting small landowners, small communities, and other vulnerable groups. We know that environmental conflicts are related to other conflicts, and the increase of crimes in the Amazon are related to the government. So we can see that there are many conflicts in this area. And we see that other regions are going through the same. And as other panelists have mentioned, mercantilization of natural resources produce conflicts. And this is different for communities because it's usually companies that arrive first and convince a community without a free and informed consultation process. And they have other purposes without any regulation protecting these communities. They're one-sided contracts. Different projects with exploiting different natural resources like carbon and deforestation, illegal occupations are one of the things that we have to face. And there are communities or leaders of communities and human rights advocates are now facing other stakeholders that want to commit environmental crimes. So information and the protection of human rights advocates is not fully in place because many communities don't have the technology for accessing this information. And they use technical language which is not accessible for communities. And having different communities and the lack of recognition and regularization of its sectors and the criminalization of human rights advocates or when they resist or when they protest represent economic disadvantages for them. And there's a lot of important work of inter-American organizations that join the situation and in many opportunities criminal law is used to criminalize human rights advocates and defenders. And here I'm going to show you the national policy for protection of human rights advocates. Either individual groups or civil society organizations that promote the protection of fundamental freedoms. And these protections guarantee the continuity of their work. It protects them when defending human rights and it protects their activities. And characterize this the, the actions against them and as a social movement. And Brazil and other countries believe that these activities and this situation of criminalization is connected to two factors, different factors. There used to be groups that were more affected, more vulnerable, and these groups live where these crimes occur. And these people, these groups, are also used as labor to commit said crimes. And this is considered as slavery work. And those who finance environmental laws are almost never made responsible for these actions. So these criminal organizations take advantage of the vulnerability of these groups and these peoples to commit environmental crimes. And when there's an investigation or a commission investigates and finds responsibilities, it's those who are more vulnerable. So they profit from these activities at the expense of these people. So, and are members of these peoples that are arrested and prosecuted. So we require a deeper investigation to find the responsibles and those who take advantage of the vulnerability of these people. This is why in Brazil we have great projects and economic entrepreneurships, public or private, that cause great environmental crimes also. And communities and human rights advocates, when they are put in this position, are also criminalized and brought into justice. So on the early stages of these projects, need to have the voices of these advocates so that these rights and environmental protection can actually take place. And when environmental crimes occur through these projects, public or private, can be made responsible. It is necessary to have measures according to the specific needs of those who are protected by human rights. And now to wrap up my presentation, I have to say that great companies cause great damages to the environment, and we need to have proof of these crimes. And it's very difficult to prove these crimes because we require investigations, inquiries, studies, and there's a problem when it comes to valuing the environmental damage, how to measure it, how to get these proofs and the evidence, and how to calculate the monetary damage and the kinds of environmental reparations that are required. So these are also challenges that we need to face, prove processes and environmental crimes, and how to measure the value of these crimes against nature. And I think that one way out of in trying to diminish violence and vulnerability of human rights advocates would be to regularize and to protect through regulations and documents that acquire permanent liability for them, and to encourage investigations of environmental crimes involving more agents. Sometimes there are international stakeholders and they require a specialized investigation. I want to pay homage to Madre Bernadette. She passed away last year, unfortunately, another victim of violence because she was defending her territory. And again, I apologize for the accent and thank you for this opportunity.
Thank you for that homage and all of the topics that you have presented for this interesting discussion. What you mentioned about how people are used in vulnerable communities to commit crimes in the environment and how that can be criminalizing of these communities that are part of defending these territories. It is very interesting when you talk about the territorial conflict map in Brazil and these challenges that are seen in persecuting environmental crimes due to causes and proof. I believe that this should be a pattern when we persecute different companies or enterprise crimes. Next, we have Sebastián Casanello, General Judge of Argentina. Unfortunately, he could not connect, but he sent a video with his intervention, which will be reproduced now. Good morning. It is a pleasure to participate in this event organized by the Regional Office of the United Nations for Environment and for the High Commissioner for Human Rights. When we work in a criminal law, we know a phrase that says that a legal law does not touch a hair on the criminal. And this is something that the criminal courses teachers start their classes, and it is just to explain the importance of the criminal laws. It doesn't mean that the criminal law does not work, but in order to be effective, we need to have the right procedures and several tools that are part of a whole, which is a penal system or a criminal system, whatever you want to call it. I prefer to talk about the penal system because it allows to create an idea of a whole that is part of all the interconnected parts for procedures, regulation, officials, judges, prosecutors. And by thinking in a systematic manner is how we can use and understand the title of this event, the environmental criminal law, the protection of environment to criminalization of people defending the environment, and also to understand the importance of the different parts of the system in order to have an impact on reality. Said in another manner is to prevent to just these be words. And if we think about concrete terms and results, it is important not to stop asking what is the justification of the criminal law, and in this case of the environmental criminal law, because this exists and what are we trying to do. And this goes back to different big questions of the criminal law. The first one, what are the justification of this sentence? So we have a big agreement on relation to this question. Even though the sentence has a retribution aspects, now it is important to also think about the use in terms of prevention. Okay, but over the years, they stopped being enough. go hand in hand with the importance of criminology and to criminal law and justice. They should be interested in the solution of the conflict. So why? Because it was said that the execution of a crime should have two mindsets in the prosecutor and the judge. First, to prevent the repetition of emerging crimes, and the other one to prepare as much as possible the impact of this crime. So when we think about the solution of crimes, is where I would like to stop, because in environmental topics, it is evident that the system should not be exclusively looking at the sentences, but also it needs to consider the solution of the conflict. And for that, particularly the reparations. So we cannot just sanction a legal or individual person if the environment will continue contaminated. And as our most important criminal lawyers, Sebastian Soler, said, we should not be thinking about the sentence as a price for the violation. If a reparations was considered as a private law matter, it was something that depends on the person executing the crime, and if the people have rights. But when we talk about environmental crimes, reparations is a matter of public interest that is part of the criminal law. The judge or criminal court needs to establish from the first point how they can repair this, and the judge, the prosecutor's office, and those that are part of the environmental criminal law. In this point, I would like to talk about the environmental crimes in their environment dimension and the characteristic of organized criminality. With the majority of times, we are facing companies that operate rationally. So these cases, the impacts will be consequences of economic impacts as well, and the conclusion that this is a good business to contaminate. And as the Financial International Fund, Gafi, is talking about the nature of low risk but with great benefits, that is characterizing environmental crimes is a profit source for criminals. In part, this is due to the regulation framework that is not always consistent internationally. And this is not completely addressing the environmental impacts and money laundering aspects as well. So, by talking about these risks, it is a consequence of talking about the common resources or goods, and it happens in many parts. It happens with a good side of organized criminality that is considered many times as victimless crimes. But these are individuals, even if we don't know the names and last names of those that are behind it. And those that are behind it are the most vulnerable sectors. So think about those impacted by the narco traffic insecurity, or those that are victims of exploitation and trafficking, and those sectors of the community that do not have good public policies due to corruption. So we always have victims, and they tend to be the most vulnerable sectors. And the same happens with environment. The economic dimension and considering environmental crimes as part of the organized criminality makes us see the importance of taking back and the opportunities that are presented in these terms for the reparation. Those goods that are taken back could be used for society in alliance with the cooperation of people and the state. And this way, the organized community will participate of the solution of conflicts, which not only will create the empowerment facing crime, but would also complete the legal work and has an extraordinary symbolic value when we talk about the defense of the state of law. And when we're talking about the environment, in the defense of environment, to imagine this, think about a forest, a native forest. that is an object of illegal felling, with the recovery and the usage here, and this could be converted or transformed in a good of biodiversity and managed by the state and people, and to have an awareness function in defense of the environment. So this, to talk about orientation, is about the current Cartagena declaration in terms of what was approved in December 14 last year. Their countries established that we highlight the importance of our countries to have regulatory and operational frameworks to ensure the correct administration of frozen goods, or those that are decommised. Especially, we want for countries to establish or to have a recovered goods as the resources that are available and taken back by the state for order officials for health, education, and all other appropriate goods. And countries said that it is important and it is relevant for countries to have effective mechanism in order to take back the legality of their correct owners, or to use to compensate the victims of the crime. So it is important to have the consideration, not only the sentence, but also the solution of criminal law through reparation. The recovered assets are an extraordinary possibility for community reparation, particularly through the development of social use initiatives. This is not existentialism, it's empowerment. This is a participation of the organized civilians together with the states in the recovery and preservation of the environment, and the regeneration of social tissue, and the state of law to carry out their work against crime. So this is not only going to repair, but will prevent this very used word by the legal system through the construction of environmental and civic awareness. Thank you very much. Thank you. Thank you, Sebastian, for that intervention. And now we have the questions. And I would like to highlight some elements of what was said, to think for the context where we develop criminality, and all the elements that we should consider for its persecution and the transnational context, organized crime, and also the movement of money laundering that could create a recovery through this persecution. So now we have some questions. We have many comments on the chat or our YouTube channel. So thank you so much for participating. And next, we have some minutes. We have just some minutes to answer some question. So we are going to ask the questions and you will have 3 minutes to answer. Now, the first question is for Gregorio. How can we sanction correctly those that impact environment, those who green entrepreneurs? So that is the first question. For Carmela, we have another question that says, in Guatemala, how the ratification of the Escazú Agreement can help protecting indigenous people? And this question is for all of you. Nor Colombia, Jamaica, or Brazil have ratified Escazú. So what is the difference that could happen for ratifying this agreement in relation to the protection of defenders of the environment? So we can do that in the same order, and you will have 3 minutes to answer. Gregorio, the floor is yours. Thank you. Excellent questions and comments. I'm going to talk about the first one. that Colombia has not ratified Escazú. Colombia already did it, but that is pending for the review of constitutionality by the Constitution Court of Colombia. That is where we have big questions, but it seems that the factive powers can prevent the approval by the Constitutional Court of that very important agreement for the protection of the rights of defenders of the environment and also going in the right path to protect the environment. Regarding the initial question about how can we sanction those green tie criminals, and I would like to start saying something that in particular, I believe that the environmental criminal law is some sort of a contradiction in its terms. In my perspective, it should not exist unless you call it as I say it, the anti-environmental law. If the right is a contradiction in the terms because does not fit, is the same of sustainable development. I have developed since 96 and 7 30 years ago. This sustainable development is a contradiction of the terms because you cannot have this when development is understood as economic growth. So the environmental criminal law cannot comply with what you said because, as I said in my intervention, the first should be prevention. That opposes radically to repression, and repression could be even such a severe damage to environment. And I tend to use this in my classes, but we say that Pedro Perez, a human being, is responsible of killing the last of a species in the world. So the sanction of the criminal law will be 10 years of prison and some fines. And after those 10 years, that extinct species, jaguar, in Amazon or in Colombia will resurrect not. What Sebastian mentioned, and he gave a very good arguments in terms of reparation. They're not reparations, so it will be very difficult to sanction green tie criminals because the majority of the law is coming from that hegemonic view, particularly androcentric of the world. And of course, in addition to that, it protects big companies because in the Colombian case, the decision of the two courts, the constitutional and the constitutional law for the Amazon forest, the Colombian prosecutor's office and the ministry, in order to protect the Amazon environment in Colombia, they start persecuting the poor farmers, but they do not investigate and persecute the big companies of agriculture that pay just minimum wages, and those farmers that are really poor or have been made poor so they can burn jungles. So this is just cutting on the weakest link because that is what the criminal law is doing. We have some greenwashing because the criminal court tends to believe that they are going to solve problems and that won't happen. So we see less crimes of green tie because that is the new way of greenwashing, where the law is tinted by green in order to believe that with those formulas that they are going to protect the environment, and that is not the case. That is why the Amazon forest continues to be destructed. And it means that when we not transform that view and we start with prevention in order to continue thinking about repression, and I know that this is complex, but we need to find other ways. Thank you, Gregorio. Mrs. Carmela, I'm sorry, is that Mario Calvert was talking in the chat and he's saying that he is about to leave. Mario, are you there to give us an answer? Mr. Calvert, are you there?
I'm still here, but I think I missed the initial question that was asked. So if you could repeat the question for me, that'd be very good.
The question is, nor Colombia, Jamaica, or Brazil have ratified Escazú. How do you believe that the Escazú agreement can set a difference if those countries ratify it for protecting those defenders of the environment? Thank you.
I think it's very clear that the exclusive agreement, allows us as a region, to protect not only nature, but people who are involved in it, and it's a landmark. I don't think any other region has an agreement like this, and we are at the forefront of it. I believe one thing, I would have pointed out in my presentation is that one thing that we get is the access to information, and access information allows us to be included in the process, but it also speaks to about the stakeholder engagement. The escazú mandates governments to include stakeholders in different activities across the region, including the drafting of policies, the drafting of different environmental regulation. And so for me, I think it allows people to be engaged in the process. It also allows stakeholders to have a more rightful place to be engaged with the government itself. So it's not just because you're a stakeholder, you're involved in the process, but a right you believe because of the exclusive. So if member states could, engage them, or if states like Jamaica could ratify the agreement, then that would be a step in the right direction. And that's how I view the agreement in a sense. In terms of protecting environmental defenders, that is something, that I believe in a sense that, needs not just an agreement or ratification, but also the application of national laws. Because you need for laws to be effective, you need also regulations at the national level to complement the regional agreement or international agreement. And it's same like different processes in the climate, in usually Paris agreement. There needs to be local framework or like legislative framework that can support its implementation. So that's one thing. This because agreement is a step, but you also have to push governments to do more. And I think that's the way we have to do it. And maybe other countries across the region may have to do that. And so for us to have a practice or a view or a guideline, so other countries could adopt. And I think that's the way to go.
Thank you, Mr. Galbert, and thank you so much for staying with us for a few minutes more and answering these questions. So thank you so much. And we have Carmela Korup. Thank you, Mr. Galbert. If you need to go, you're free to go. Thank you so much. And now we have Carmela Korup, who is going to answer the questions. Thank you for that question. And in Guatemala, the Escazú agreement is not ratified. We have some indigenous people movements that are having some meetings and to have some approaches to these governments, but I think that this is going to be a really long path. And I would also like to take this opportunity to say that we also believe that we want to change that paradigm of human rights, Mother Nature, water, natural resources. Well, just one. So we are going to start changing our communities in order to see how we are going to protect the environment. How can we prevent to pollute? How can we find other spaces for using those contaminating elements? From that scenario, I think that we need to consider our future reviews and that is aiming to prevent environmental pollution. And to say that the Escazú agreement will make more democratic the decision, not only to put it in the hands of the state, and how we can grant a license, how we have established for the informed previous consultation and to not leave the state to decide about our lives, but they need to have a dialogue with us and to review and to inform. And together, we need to make this decision. And at some point, we have found that some indigenous people have said, how can we use the 189 conventions in order for the states to listen to us before making a decision when it comes to natural resources? So I think that the Escazú agreement is just considering this mandatory participation that is forcing the state to ratify Escazú, and that all civilians can say our opinion and what will be the impacts of this project and to make our objections as well. I think that those are the main points to have timely information access, and we have access to public information, but it is very long in order to see if there is a license in progress, because we need to give very specific details that will not help us in order to determine if some projects or some licenses are in progress. And the other important topic is about how we, as defenders of the environment, and it's can present our opinions without receiving any retaliation, and that present and activate and to make the process to go through the prosecutor's office, and that the proof is a very important topic. We don't have all the mechanisms and the resources to be able to prove to the judge that this pesticide contaminated our rivers, but that investment to have the proof should be on the shoulders of the state, because they have the resources in order to implement that. And the judge will say, I'm sorry, we are going to collect a sample on that day, and nothing happened. And of course, because the pollution was a month ago and the water is already moving and flowing, so that disappeared, but it will happen again. So we don't have strong mechanisms for monitoring and to find at some timely moment to be able to obtain the proofs. So this is part of the many weaknesses of the system. We have been unable to progress in terms of the criminal prosecution due to this, and then the reparation aspects is just a fine. It is enough. There are not criteria or standards that are strong enough so we can regenerate what was damaged or killed. So I completely agree with when it was said that what the judge mentioned, which is to execute many benefits for contamination or pollution. This will be more beneficial than to repair it. So I think that we are part in a system that is only favoring the destruction of nature. And the idea is to continue promoting how we can use water, and water is a me. So if I take care of you, you will take care of me, and together we can use a civilization model that will be stronger and for more time. Thank you.
Thank you, Carmela, so much for your kind words. We're now going to give the floor to Ione, that would be the last to provide an answer. Thank you so much. I think that environmental crimes affect everyone, society, and the entire planet. This is why climate crisis affect groups and vulnerable communities even more, indigenous peoples as well. And an agreement like the Escazú agreement is very important because in many countries draft national laws. And with that, there's a reinforcement of the guarantee systems for protections, especially for groups that are more vulnerable and that require the participation, and they're the most affected with the climate crisis. There are many things in common, and I agree with everyone that spoke before me, and I wanted to thank one more time for the opportunity. Thank you so much. If there are no further comments, I just wanted to appreciate all our panelists' participation, of all those who followed up on this broadcast on YouTube. And we have a lot of resources for our own countries. And what Mr. Mesa was saying, it is also something that we hear in our panelists' intervention. Criminal law and this punishment fever is not a great for the protection of the environment. I think Mr. Mesa wants to say the final word. Thank you so much. Two very brief ideas. Thank you for all the interventions. And the first thing I want to say is what Carmela says. In Colombian law, we've made a lot of progress in liability. So this is a great moment in working in criminal law, because it's not just the burden of proof, and shouldn't this is something that we've been struggling with since the 90s. So we could take this idea of objective liability in environmental issues and take this to environmental crimes. And the second thing has to do with this idea of the one that can pay is not a criminal, but it is rather an entrepreneur. This idea is the one that contaminates space, is against environmental principles. Therefore, this awards the great criminal, and it prosecutes the weaker part, which are peoples and organizations. Thank you. Thank you so much, Mr. Mesa. And I understand that there are no more interventions. Thank you so much, everyone. Thank you for being here. Thank you for sharing your experiences and your wisdom with us. And I also want to thank everyone who followed up us on YouTube, this official side event. Thank you and have a great day. Thank you.